Good afternoon, people. This is Clarissa Williams coming at you today. First thing I want to do is make sure you always check out my YouTube channel. I'm posting videos on there. I got a lot of them actually posted. It's called Clarissa Speaks the Truth because that's what I do. And I created that YouTube channel because I wanted to share with the world that Greenville, South Carolina, Department of Social Services and Family Court, House judges, 4 of them, have tried, involved in actually kidnapping of my daughter. They involved in trying to cover it up. DSS kidnapped my daughter from school December the 14th, 2021, and they used falsified documents to secure an ex parte order. That ex parte hearing, there's no proof it took place. Supreme South Carolina Judicial Branch say they don't even have a copy of the transcript. They said my hearing is not on her recorder, and I knew it wasn't. And they broke a law when they filed the petition. The case was supposed to have been closed on December 11th, 2021. They filed those documents with South Carolina, Greenville County, South Carolina Family Court on December the 13th. That was the law. They knew that was wrong when they did it. They never told me I was under investigation for physical abuse and medical neglect. Now listen, I ain't put a finger on my child. I ain't hit her. I ain't pushed her. I ain't hurt or harmed her. They're alleging that the physical abuse came in where I took her to the doctors too many times. She was sick. Her doctors gave her referrals to specialists. I had to take her. If you don't take her, that's called medical neglect. So I took her. She was hemorrhaging. She was having fever. She was fatigued. She had rashes on her skin. She had severe abdominal pain. Oh my God. Her she had nosebleeds. Her hair was coming out. Something was biting our skin. A whole bunch of symptoms this baby had, and the doctors couldn't figure it out. And the doctor that filed the report, I don't even know him. I don't know that Dr. John Mayer. He's never seen my daughter, met her, talked to her, examined her, or treated her. I don't even know where that man came from. This whole case is botched, and some of these documents, these court orders that I have from these judges, they're falsified. They're full of lies. This is fraud on the court. So we're going to get back where I left off at. That's just to bring you up to speed, because these videos, they're going to hit the Department of Justice and the FBI and the United States Attorney General. They ain't getting out of this. Ain't nobody in this country above the law, and I'm standing by that. And I'm not going to leave these 2 agencies alone until me and my daughter get justice and they exposed, because I'm a whistleblower. Okay, so let's pick back up. This is a probable cause hearing that I went to on December the 15th. 2021, the very next day after they took my baby and placed her in the foster care. Yep, they placed her in the foster care for taking the sick child to the doctor. Now, let me tell you how we got sick. Found out we had mold inside the HVAC system. That mold was all up in the air ducts. We was breathing that stuff, and that stuff was in our mouths. It was growing on our skin. I've had some lab tests. It came back positive for a couple molds. One was in my mouth and my sputum, and the other one was growing on my skin. We kept getting all kind of fungal infections, bacterial infections. Come to find out, lead was in the water pipes, and the water pipes were corroded. Okay, state of Georgia said those pipes are corroded. Anything in that ground, microorganisms can come up through those pipes and could be hazardous for your health. It could be hazardous for your health. So that's how we got to this. That's why they took my baby. So let's look. So this is Judge Rochelle Conits. We went December the 15th. So I left off on number 30. But a few things I want to go. I said I'm gonna go back and talk about these few little things. I left off on number 30. But we're going to come back to it, because one thing I need to make sure I show you. This is I tell you, this ain't an ounce of truth in this document. All lies. Sure is. And I want my Supreme Court in South Carolina Appeals Court to see this, because you need to know when those ladies issue those orders, they fraudulent, okay? And y'all don't even see them. You don't get those, but you need to start asking. Need to be law where they got to send this to you too. Okay, so this is a lie. This is her signatures on this court order. Based on examination of the file and the pleading. So she said she read this and the pleading. She read it. You examine this stuff. So I don't even understand why it's lies all up in here if you read it. Okay, then it says, and recommendations of the guardian ad litem. The guardian ad litem are making the recommendations. They took my baby on December the 14th. I saw them people in court. I don't even know that guardian ad litem. It's a little couple, and Attorney Dustin Davis said, all they do is get in their car, they retire, and run around and give people a hard time. He said they the worst guardian ad litem to have. Sure did say that. So I'm gonna show you how this is a lie. They ain't making no recommendations, okay? So this is what we're gonna actually start at when we get to the guardian ad litem. Now, this is the transcript. And I showed it to y'all before. I'm going to show it to you again because this is so critical. December 15th. See that? Judge Rochelle Conits. Exclusively. So let's read page 24. This is when we was ending up the court session. The court is Judge Conits. The court. Okay. Here you go. 7-8 line 789. The court. She said, guardian, any court. See, this is my attorney was finishing up. No, Your Honor. So here go attorney. I'm sorry, Judge Conits. Guardian, questions? The guardian, no questions. Here go Judge Conits. Okay, thank you. You may step down. That's Haley Rogers, because she was the only witness DSS had. Or she was the only witness, and we know she a liar. So what kind of recommendations did Jackie and Jerry Land make, Attorney Conits? She didn't make none. That's a lie again in your court order. I'm going to keep busting you. This is criminal. This is public corruption to the highest level. This is not the truth. The court orders keep flying out that courtroom with these judges, and they full of lies. So that's a lie right there. They ain't make no recommendations, okay? They could not have, because they was just assigned this case on December the 15th, and I'm prove that too in just a second. They was just assigned this case. Get a little paper up. Here we go. Now this is order appointing guardian ad litem and attorney for guardian ad litem. December the 15th, 3/12. Remember, I went to court at 2 o'clock, December the 15th. I crossed my baby's name out. This is us. This is that little couple, Jackie and Jerry Land. A volunteer, not volunteer acting like that. Her serving on behalf of the cast, Elias McCarter, guardian ad litem program. So, okay, so let's read it. Okay, there you go right there. It was on December the 15th. So they had just got appointed. So that tells you they ain't know nothing about my baby. They ain't know nothing about her. How you gonna make a recommendation they talk to me? December 15th, look at that. We're gonna get back with this. Okay, so I'm gonna read you the law on it. I'm gonna read you the law. Now, it says legal representation of children. It says a guardian ad litem serving on behalf of the South Carolina Guardian Ad Litem Program, or Richland County CASA or CASA, must be represented by legal counsel in a judicial proceeding pursuant to Section 63-11-530C. You see that? Must be represented by legal counsel. You represent it. That's what they were supposed to be at that hearing on December the 15th. Okay, it says must be represented by legal counsel. Okay. So we're going to flip back real quick again. And now this right here, this is probable cause order. This right here tells you all the parties who was there. Their attorney was not there. Don Stevenson. Don Stevenson. Here you go right here. Here you go on his court order. He wasn't there at this hearing. So how could they can't do it? They got to be represented by the attorney. He wasn't there that day. See, I caught you. This is illegal. This is criminal right here. Now, look at this probable cause hearing. It's showing you everybody was there. That's why I have some strong reservation about this court order. This court order ain't no transcript. They don't have no such hearing. Nothing saying this hearing took place. It wasn't even on the docket. This is what Judge Tarita Dunbar signed. Because I told you this, they commit crimes against people in public, me. And y'all too, I'm sure. These people don't follow rules and laws. That's why I'm posting these videos so you can see firsthand. And I want y'all to take it to y'all attorneys or another judge when you got to go in there and show them how much corruption going on over there. So she signed that. So look, who appeared? Judge Tarita Dunbar and Sam Weldon. I told y'all, the attorney told me we don't really have a hearing. We just asked the judge to sign the order. That makes sense to me. And they present no evidence against nobody taking people, children in Greenville County, South Carolina. Ain't nobody there because ain't nobody attending. On belief and information. So that's a lie, Judge County. Yep, I'm calling it as I see it because I'm fighting for my reputation, and I'm approved. They like that. These people are liars over there, and I'm approved. So okay, so we're gonna keep rolling now. We're gonna go to the next one because we know I just proved that was a lie. Okay, so let's go to the other one I want to go. I want to back up at. Is this one right here? Let's go back. This is a disgrace right here. The plaintiff made the following efforts to prevent removal. They got to offer you services, try to work with you, send you to parent class, a safety plan, have somebody come make sure your house is clean. I ain't none of that criteria fit me. Okay, they just took my baby because they didn't know what to do, and because of the color of our skin, African Americans, the way they talked and treated me and my child, and we both telling you we sick. Now you got the now that Judge Conits, she got a copy of those mold reports inside that apartment. And she also had copies of doctor statements and doctor testimonies that my daughter had parasites. But she still tried to find me guilty. Okay, and have evidence there. Okay, first it says no services were offered at the time of the removal. DSS had no prior knowledge of this family prior to the removal of the minor child. Number 3, it says or. Okay, so that means that one don't apply because it says or. One of the two, so we're going with this. DSS had prior knowledge of this family. DSS was not aware of this family. They said they had prior knowledge of this family. I went over this one so many times. See, it ain't even funny. So we're going to come back to it real quick. Had prior knowledge. Let it saying. This is just a crime shame. So you had prior knowledge. Now, when you look at this, Haley Rogers, that's that little caseworker that lied over there, affidavit of reasonable effort. DSS did not have prior knowledge of this family prior to removal of the minor child one time, and DSS had no knowledge of this family prior to the removal of the minor child, and DSS was unable to provide services to prevent necessity of the removal of the child. Why was you unable? You could have told me when you talked to me on November the 3rd that you wanted me to do something. We met at that Waffle House and the Taco Bell. Okay, no services have been offered for this involvement of this family. That's breaking the law right there. She just said no services. Okay, so you ain't do nothing. Nothing. Okay. So now, okay. Then she said services made available. Now, she said DSS did not have prior knowledge. Now, this one she said they did have prior knowledge. The services made available to the family before DSS assumed legal custody were. This is just saying the services they made. See paragraph 3. It don't apply. Remember, we can't use it. We got to use either one of them. That's a bad. That's stupidity. We're gonna come down here. The plaintiff made the following efforts to provide these services. See paragraph 3. That don't apply. It's one of these two, right here or down here. See? That was stupid. Just look at that. Very unintelligent people. Number C. The efforts did not eliminate the need for DSS to assume legal custody. See paragraph 3. What efforts? Paragraph 3 ain't checked. That don't apply. Remember, you didn't check it. It's one of these two. Oh, God. That a meeting was conveyed as required. 63, that's 640 persons. And persons present and the outcome or the reason. Now, if they said it was conveyed, they check it. You wouldn't check that because you said that applied when you put the check. Or the reason for the meeting not being held. Now, which one was it? The meeting was conveyed or the reason for the meeting not being held. You just said it was held, so you don't need a reason. See, look at that. Are stated in D3. Go back up. Now they put a D in front of it. That just says number 3. That don't apply, remember? See, these people done got so comfortable breaking, because all those judges let them do this. They let them do this. DSS gonna be stopped if those judges stop them. They ain't doing it. I'm telling you, it's a benefit for these judges to be doing this, taking a chance on their livelihood or getting some charges placed against them. DSS made the following efforts to place the children with a relative known to the children or in another familiar environment. They said they made some efforts. Then it says, or in another familiar. You ain't made no efforts. On December the 15th was when we went in that courtroom. And this order was issued after the 15th because it's stamped on December. Tell you what day it's stamped. December 29th. So between December 15th and 29th, that's a lie. Okay? And I'm gonna tell you why it's a lie. I'm gonna go back. Right here. They said, okay. We're gonna back up. Okay, that's how she lied. Now, that's how she lied. Now, make sure you see this. DSS made the following efforts to place the children. She ain't make no efforts. She ain't even told me I was with a relative known to the child, or in another familiar environment. She ain't familiar with nobody else environment real strong like that. Known to myself and my aunt. And my aunt wanted my daughter to come home with her that day, and Judge Rochelle Conits wouldn't let her. They ain't had no evidence that I hurt this child by taking her to the doctor. So I'm gonna show you. Now this is Judge Conits' question. Okay, no, I'm sorry. Let me see. This is, hold on. This is Sam Weldon question Haley. Okay, this is their little thing right now. Question. So look, it says, here goes Sam Weldon. All right, now since the child has come into care, have you spoken, mother, about potential relatives for possible placement of the child? It's on December 15th. Briefly, yes. And did you get the names of, and did she give you the names of anyone who may be able to have placement of the child? She said, yes, she gave me the name of the aunt, a great aunt to the child. I ain't gave you nothing. I can't. I have it written. Okay, is that potentially this lady that's here with us today? My aunt went to court with me. Just me and her on the other side. Yes, sir. All right, and does the department have any issues with checking this out for possible placement of the child? No, we can assess her. So on the 15th, they could have let my aunt, they could have done that and had that thing and report they was going to do. Well, we know they don't do background checks. If so, they would have found that her dad was a convicted felon, had 2 felony convictions, was on probation, had a probation violation, and has done over 10 years in prison. They would have found that. So they ain't find that. My aunt is a good law-abiding citizen. My aunt should have been able to have placement of my daughter. So I called them in a lie again. You did. She was sitting right there in the courtroom with you, on the other side of you. Okay. So we gonna keep rolling, and so I done showed all of that. So I'm gonna try to keep moving. I'm gonna try to keep this video. Like I said, I stopped at number 30. So the probable cause. Okay. Exists and continues to exist for the minor child remaining in physical and legal custody of DSS. Now, if you read the determination fact sheet, it just said all I did was take her to the doctors. And that's what I'm supposed to do when she running fevers and sick and everything. We both were sick. Okay, so it says that the attached placement plan dated December 15, 2021 is hereby incorporated into this order. Now, Sam Weldon gave me this document that he filed with the clerk of the court. It's the summons, hearing and right to counsel, and the complaint. Okay, so look at this. Now when they gave this to me, stamp, all of them stamped, December 14, 112. Show you the next document. Okay, that was at December 14, 113. So this was attached. 1 minute later, boom, stamp. Okay. So this is the placement plan on December 14th. Now, I don't know why it's 2 different ones. On December that's dated. One dated December 14th, the other one dated December 15th. Okay, so we're gonna read this one. One that Sam Weldon filed with the clerk of the court against the one that placement plan that came in the mail to me. I'm gonna show you how that works. Let you see it real quick. So we're gonna flip over. Because you need to see this. 14, 15. They didn't file this one 2 weeks later. Okay, so we're going to go with Judge Rochelle Conits. Now look, she said that probable finding, she had a finding regarding probable cause, that there was and remains probable cause for law enforcement to take emergency protective custody of the minor child, and for the Department of Social Services to assume legal and physical custody of the minor child. She was already in y'all care on December the 14th. So I don't even understand why December the 15th you had already put her in your care. And law enforcement didn't take my baby. Let me show you how these people are liars. Okay, I'm gonna show you. They didn't take this child. Let me see this. It said law enforcement ain't take my baby. Look. This is the petition. Well, I'm gonna go. That's not the petition. I need to show you the petition. This is a petition that was actually filed against me. That's saying, well, now it looks like it's been photostatic copied so many times. This is it. Petition. You see that? Who is that to take my baby? South Carolina Department of Social Services, DSS. Law enforcement ain't have nothing to do with this, so y'all need to stop that. So I'm gonna show you how law enforcement. Now, this is the order that Judge Charita Dunbar issued, December 13, 2021. Okay, so I'm gonna read this part to you, so you know these are liars. I'm telling you, honey, they got a good little illegal racketeering ring going on over there. And I read this. Number 2, if requested by DSS shall be accompanied by a duly authorized law enforcement officer when it attempts to take the child into custody. If requested, so that means you got to call the law enforcement and ask them to come. Okay, so you already the plaintiff, so you're asking them to come with you, to accompany you. Law enforcement, and I don't even know if you actually called them, but law enforcement ain't had nothing to do with this case. Okay, so I just showed you that. That's December the 14th. Now look at this, December the 15th. Finding regarding probable cause that there was and remains probable cause for the court. Now they say in the court to take emergency protective custody of the minor child or children, and for the Department of Social Services to assume legal and physical custody of the children. Okay, now, so look, 2 different things. December the 15th, they forgot, told a lie, told you, said law enforcement. On this one, the courts did take custody of her through ex parte petition. Okay, so we're going to keep going. That's a lie. Look at that. Then when you flip it over, this when it gets very interesting with these liars and criminals. They get away with it. Don't nobody stop them. I'm telling y'all. I'm the only one been brave enough to do what I'm going to do, and I ain't going to stop because I want them all getting disciplined. I really want to remove them. This is serious. This is very serious. Okay, so look. Second page, I'm going to fold it back because I want y'all to see these side by side. Yep, I want you to see them side by side, honey. Now, this one, I told you this is the one from Judge Conits, December 15th. There you go. Little second page. This is the one that Sam Weldon filed. They see they don't forget. They got so comfortable over there. Some 14. Y'all can see this camera rolling right to the front. Now it says services provided by the department. December 14th. Services offered that under the circumstances and based on the nature of the allegation, DSS does have prior knowledge of this family prior to the removal of the minor child. Does have prior knowledge. Now remember, on this affidavit of reasonable effort, does have prior knowledge. So I'm going to take you to Katie Rogers' sworn affidavit. It's a sworn statement. When you're in court, you got to tell the truth. Go tell the truth all the time. But you didn't. Okay. Affidavit of reasonable efforts. Signed and dated December 14, 2021. DSS did not have prior knowledge of this family prior to the removal of the minor child. DSS had no knowledge of this family prior to the removal of the minor child. She said it twice. That's about 3 or 4 lies right there. Okay? This is December 14th. On this one, December 15th, services offered. None. You said you didn't offer me none. Now you're saying due to the circumstances. And now on this one, you said does not have prior knowledge. Now you don't say that over here. Number one. I wish I could get far enough so y'all can see them. Okay, December 14th, number 2. Why services not successful in preventing custody? Service would not have prevented EPC from taking place. Why were they not successful? So that says you didn't even do them. You just said services wouldn't have prevented it. You didn't do no services. Okay. So let's go back to Judge Conits' court order that she signed and filled out. Okay. I'm going in on Judge Conits today. Okay, so let's look. Because this is the truth. This guy, she got to be exposed. She got to be exposed. Okay. I want y'all to see this. Now, here we go. Because I'm flipping back and forth. Now, look. He said no services were offered. All up and down this Judge Conits' court order, it says, there's a court order that she signed. Services made available to the family prior to the family before DSS assumed legal custody were, see paragraph 3, ain't nothing checked. Remember, you got to do or, this one or that. The plaintiff made the following efforts to provide these services. See paragraph 3. They didn't say no service. Look, blank. Right here, the efforts did not eliminate the need for CPS to assume legal custody. Because, see, number 3, ain't checked. Somebody don't have any common sense. Did this. That a meeting was conveyed. Okay, we ain't got to go back down there. Let me see. And then down here, the efforts described above are reasonable and realistic under the circumstances and other services would not have allowed the children to remain safely in the home because of the circumstances of the plaintiff's first contact with the children. Okay, the efforts described above were reasonable. What efforts? Show me anything that you said you did to not take my child. Place her with a family member. Give me parenting classes. Lots of things. The safety plan. Oh my God. See, this is a lie. They ain't did it. This is a lie. So now we're going to go back to the placement plan. Okay, so we're going to keep moving. We're going to keep moving. Because y'all need to see this. This is real. And this is real. Go back to the placement plan. Okay, number 3, on December the 14th placement plan. A meeting was conveyed as provided by 63-7-640 with the following persons present. No meeting took place. You said this 63-7-640 did not take place. That's a preliminary investigation here. So I'm gonna let you see. You need to see this. This is real. I'm telling you, these people gonna knock on your door. Six-way preliminary investigation. That's what it is. The department should conduct within 24 hours if a child was taken into emergency protective custody by law enforcement or pursuant to ex parte order. That's me. A preliminary investigation to determine whether grounds for assuming legal custody of the child exist and whether reasonable means exist for avoiding removal of the child from the home of the parent or guardian or for placement of the child with the relative. Means for minimize the emotional impact of the child or separation from the child's home and family. During this time, the department, if possible, should convene a meeting with the child's parents or guardian, if possible. So, corrective actions, including placement of the child. Okay. So that's saying 640, you're saying this is a meeting. Okay. Now, when you look right here, this how you know the it said no meeting took place. No meeting took place in the placement order. But when you go back to Judge Conits' probable cause, court order that she signed, look at this. I told you these people don't have no common sense. I guess they thought I was slow. No, I ain't slow. About that a meeting was convened as required by 63-7-640. And then they put another sentence. The persons present and the outcome or the reason for the meeting not being held are stated in D3 of the plaintiff's treatment plan, which is incorporated and attached. Okay, so D3 ain't no D, but there's a 3. Okay, the persons present or the outcome or the reason for the meeting not being held are stated in D3. That don't even apply. Because you said you checked it right here that a meeting did take place. Over here, you say no meeting took place. Then you say a meeting was conveyed with the Lord have mercy with the following persons present. Now we're going to go back to this one. This is a yo-yo game. These people crazy. They got so comfortable. They don't call it that because they know ain't nobody going to stop them. I'm saying the Supreme Court of Appeals, so I don't know what's going on over there now. It's getting too deep. Okay, then it says a meeting was conveyed. See that? Now they're saying the meeting was conveyed. Right here they say no meeting took place. A meeting was conveyed as provided in 63-7-640 with the following persons present. No meeting took place. Okay. What it did, that's the first thing they agreed on. No meeting took place. Is what you say right here. But on the court order, it said a meeting did take place with a check mark. Efforts to place, well, let's go to the December 14th. Efforts to place with relative to the Department of Social Services could not complete home studies on suitable relatives or adults or relatives. Okay, the Department of Social Services could not complete home studies on suitable adults or relatives. That's a lie. Remember, first of all, my aunt was in the courtroom with us on December the 15th. Sure was, and I read that to you. I read that out that transcript. I most certainly did. And read it again. Because these people got to get in trouble. They got to get in trouble. They got to stop this. They criminals that commit crimes against the public. It's this deep. Okay. Now, this is Sam Weldon questioning Haley. All right. Now, since child has come into care, did or have you spoken to mother about potential relatives for possible placement of the child? I mean, I ain't spoke to that lady. I spoke to her on November the 3rd when she hand delivered those papers to me on December the 14th when they took my baby from school. Briefly, yes. And did she give you the names of anyone who may be able to have placement of the child? Yeah, she's saying I did. She gave me the name of an aunt. A great aunt to the child. She said when she talked to me back in the past, because she only talked to me once. This happened on December the 15th. So that means she had to be talking about November the 3rd. She gave me the name of a great aunt to the child. I can't, I have it, look at all the stumbles. I have it written, and then he go, attorney, Weldon. Is that potentially this lady that's here with us today? My aunt was in that courtroom. They could have sent her home with her. Yes, sir. It wouldn't take them that long to do a background check on her. She clean. All right, and does the department have any issues with checking out this aunt for possible placement of child? No, we can assess her. Okay, they could have done this on December the 15th. Probably would have taken a few days or so because my aunt came up there with me because she wanted custody of my daughter. So that's a lie. And then she said didn't have no suitable. How do you know what's suitable? What defines suitable? Suitable. What is your definition? Her daddy is not suitable. The one that's done the time in prison. But my aunt is. So how would you know that? You ain't talked to nobody. How would you know that? Who said they weren't suitable? So now are you saying that I gave you my a relative's phone number or contact information or not? Because I'm gonna show y'all she's a liar. Let me show you. Now, she just said suitable. I ain't provide her with that. Okay. I ain't provide you with nothing. Okay, so let's read the complaint, because I highlighted this. Okay, now let's read this. Clarissa, due to Clarissa not complying with DSS, they ain't asked me to do nothing. What you asked me to do, I didn't do. Show it to me and write, email, whatever. And refusing to name a potential relative or a potential caregiver. She just said right here, I gave her the name of a great aunt. See, now she's saying I refuse to. And refusing to name a potential caregiver. You see that lie? You see that lie? I refuse to. Now I just read you the placement plan. That's a lie from the pits of hell. Okay, so I just read it to you. Not suitable. She said I refuse to give her contact information. Now she's saying it's not suitable. I'm gonna show you another lie she told. I gotta cut these videos down. I'm trying to. Trying to find it real quick, wait, honey. I'm about to end this video. Okay. Now she said I refuse to give it to her. Then she said she told another lie, and then she told this lie. Okay, December the 1st, 2021, action update. And it said it was, I guess, the dictation 12/2/2021. So on December the 12th, I told you I ain't talked to that lady. How did I talk to her? She got to prove that update. The mother does not have any family or friends that the child can stay with. That's 3 lies she just told. No suitable adults. I refuse to cooperate. And now she's saying I ain't have no friends or family. Look at that. That's a lie. That's Haley Rogers' lie. Okay, so I'm going to wrap this up. When I pick back up, let me tell you why I'm going to pick back up on this real fast. Because this is serious. All these judges involved. And then look, type of hearing should serve as a 72-hour probable cause hearing. It ain't even signed. Look, this is a court order. This is attached because they referenced it. It's not signed, Judge Conits. That's not even a legal document. That's void. They don't have a signature. You can't issue a document. So this placement order was null and void. See that? See what I'm saying, y'all? So this is actually a disgusting crime shame. So I'm gonna tell you. So we left off at 30. I went through the 31, the placement plan. So when I pick back up, I'm gonna pick back up at number 32, down on this bottom, up in here, and we're gonna keep going. Clarissa Speaks the Truth, because that's what I do, and that's my YouTube channel. And make sure you tune in, follow me, because I'm not gonna leave these people alone so I can get somebody prosecuted to the fullest extent of the law. Have a good day.